Hello everyone, welcome back to the course on Law of Dispute Resolution in International Trade. In this session, we will going to learn what can be challenged. In the previous session, I have discussed about the scope of WTO dispute settlement system. The scope is given under Article 1, which provides very clearly a dispute has to be from the covered agreements, and answer to the question what are covered agreements to that is given under Appendix 1. Now let's move to the most important and crucial issue, that what can be challenged in WTO dispute settlement system. Now if we will going to read various provisions given under DSU, there we will going to see a reference which has been given to the term measure. But this measure is nowhere defined in the entire agreement, what amounts to measure. And if you will going to read the cases also, the one thing which you will going to see commonly, which will going to appear in every case, complainant has challenged the measure of United States of America, complainant has challenged the measure of China, complainant has challenged the measure of European Union, or so on and so forth. So the entire effect is on this particular term measure only. And in practice, if you will going to see, first I'll going to give you an example of that so that you can understand that what is being challenged over here and why this is called as measure. Now, as you all are familiar with this now, that all the WTO agreements, be it under Annex 1, Annex 2 or Annex 3, Annex 1A, Annex 2, including GET, services or your trips, they all provide for various rights and obligations. Okay, and when there is any sort of violation to these provisions of Annex 1, okay, or Annex 2 for that matter, then you will going to see a case which is brought by the affected WTO member. Okay, this is the first thing. And second thing which happens over here is, let's say this thing, for example, and let's take the very realistic illustration. As we all are familiar that United States in very recent past, in last 3 or 4 months or so, has announced various increase in tariffs against various WTO members. Okay, so the action of United States of increasing the tariff by 50%, 60%, 75% or 100% is an act which is done by the US, and the other countries who are affected out of this particular measure, of this particular act, they have challenged that. So this particular act of United States of increase in tariff, the other countries, the other WTO members, they have presumed as a violation of Article 2 of GET 1994. Okay, so this is a measure which you challenge in the WTO. In the easiest understanding of the term measure is what? Any action which is attributed to the government. And when I'm talking about government, a WTO member government, any action which is attributed to the WTO member, that can be challenged. Because now in this particular situations, all the countries which are affected because of US measure, okay, they have filed or they will going to file a case against United States. Okay, so for them this is a measure. And why they are doing so? Because this particular action of United States is attributed to US, and in the understanding of the other members, this is a violation of various provisions of WTO agreement, and in this particular situation, violation of GET 1994. So this is one such example. Okay, and in all the cases where you will going to see where the cases are brought to the dispute settlement system, okay, they challenge what? They are challenging any action of the member. Because one thing which is very logical and common is why you are doing that, because that action is attributed to that WTO member. Okay, and in practice also, if you will going to see that what is getting challenged in WTO, no doubt that this a measure, a action of some WTO member which is inconsistent is challenged by the complainant, but it can be in the nature of a legislation. Okay, it can be an administrative act, it can be a conduct. So there are various possibilities. The scope is very wide when it comes to measure that what you are challenging, and in this particular session we're going to understand this particular aspect. Okay, now let's start first with the bare minimum requirement. Okay, and most of the claims, they lie around this particular provisions only. Okay, act versus omissions. Now, what is the meaning of act over here is, let's say United States, China, European Union, India, Korea, they all have come up with a particular measure which says that from 31st May 2026, we will going to charge 200% import duty on any of the electronic items. Okay, now this is an act which these countries or WTO members have done. So what would be the repercussion of that? That there would be some WTO members which are affected because of this particular act. Okay, and what they will going to do? They will going to challenge that to the WTO. So how they are challenging this thing? First, they're going to say that this particular act is attributable to these WTO members. Okay, and these WTO members have done some sort of act which they were not supposed to do. That is a violation of WTO agreement, and that's why we are challenging that. So this is known as act. There are various examples of that, like any country if they have increased the tariff, or if any countries they have come up with subsidies scheme, okay, or any of the regulatory conditions are imposed by the WTO members, they all are acts. They can be challenged provided if you think as a complainant that these measures are inconsistent with the WTO, various WTO provisions. Another types of complaints which you will going to see, the scope of the complaints actually, omissions. Now under some of the WTO agreements, you will going to see that there are various provisions which says that WTO members are expected to do or they should do XYZ things. And the moment you are not doing these XYZ things, okay, you are in breach of WTO agreements. So now complainant will going to file a case in the WTO dispute settlement system stating that you have omitted an obligation which you were supposed to do. So this also amounts to a measure. Let's understand this thing. Under Article 1, okay, of GATT 1994, there is a provision of MFN which says that countries or any WTO member should not discriminate in or among the WTO members. And let's say if any of the country is discriminating it, this is the omission. Okay, you were supposed to do something and you are not doing it. This is again a violation. So in this situation, what you will going to do? You will going to challenge this particular action, okay, to the WTO dispute settlement system. So this is a scope of acts versus omissions. Any of these can be brought to WTO dispute settlement system. And this demarcation is just for you to understand it. When you are bringing a case in WTO dispute settlement system, you are not required to categorize it that is this an act or a omission. You just have to show that this is something which is done by the responding member and how you think it's a violation of WTO provisions. Okay, and now let's move towards the next requirement. As I have already explained you this particular part, that when we will going to see the entire scope of WTO dispute settlement complaints, you will going to see that sometimes a challenge has occurred in various possibilities. Now this is a very important distinction over here. Now what is the meaning of unwritten measure or a composite measure? Understand it like this. Items which are coming, let's say, from United States, Japan or Korea to India. Okay. Now regarding that, when they enter into our commerce at the border, we have imposed various requirements. Requirements can be in the terms of licensing, requirements can be in the form of inspections. There are various things are there, and we don't have any specific law to that particular effect. There is no specific law which says that there need to be an inspection of the consignment which is coming from China, Korea, Japan or US for that matter. There is no as such law which says that there need to be an import licensing, okay, or XYZ other things. And all these actions, they are done in practice, in conduct, which are not supported by law, because we don't have any law regarding that. This is known as unwritten law. Okay. Now the most important question which comes over here is, can you challenge such practices? Answer to that is yes, you can challenge that. Okay, how you will going to challenge it? That this is an unwritten law, but the way the practices are going on in this particular country, okay, that is inconsistent with the WTO obligation. So this increase the scope of complaint, okay, just because a WTO member has not formally passed a legislation, that will not going to shelter him in order to raise a complaint. Okay, other members will going to raise complaint against this particular member. Okay, despite there is no formal law. And now what you are challenging over here is that the practices are like that which are inconsistent with the WTO obligations. There are so many cases to that. Okay, one is a very famous zeroing dispute, which is between US and European Union, and other countries are also involved in that, Japan. Now in United States, and this is something which is related to anti-dumping and a very, very complex dispute. I will not go into the detail of that, but I'm going to encourage you to read on zeroing dispute. But I can give you an example in a very simple manner. So whenever any WTO member dumps some item in another WTO member territory, okay, and if there is a finding of dumping, then that country is allowed to impose anti-dumping measure. That is the formal structure of anti-dumping. Okay, now the problem is that how you will going to calculate the dumping margin. For that, under Article 2 of anti-dumping agreement, there are provisions given. But sometimes some countries, they deviate from that. Okay, you don't have a very formal rule in your own country that how you will going to calculate the dumping margin, but your practice is like that which is inconsistent with the WTO obligations. So how you will going to challenge that? Okay, will you going to argue that in my country there is no written law, and if there is no written or formal law, how you can challenge that? So as a complainant, you will going to argue this thing that we are challenging it as a unwritten law. But if you will going to see the practice which are followed by administrative authorities or the conduct of administrative authorities, they are like that which are inconsistent to WTO, and that's why we are challenging this particular measure. Though we know this is an unwritten measure, there is no formal law which has been passed by the parliament or other competent authorities. Now some of you might be aware that European Union is coming up with CBAM legislation, carbon border adjustment mechanism. Though it will not going to qualify into an unwritten law. But I am giving you an exercise. Please try and explore this thing, that if the CBAM has to be challenged as an unwritten measure, how or what changes you will going to make to this particular thing. Okay, as of now, this is a written law, but if you have to make changes to it, and if you have to make the CBAM into an unwritten law, what changes which or you will going to do to that. Now second is composite measures. Now sometimes you have a particular measure which has various trenches to it, and that particular measure or series of legislations, each one of them individually, they are not violating any of the WTO provision, but when they are all put together, okay, then they violate WTO provision. So for that, what you can do, you can challenge them as a composite measures, because they are individual acts or omissions which might not be inconsistent with WTO provisions, but collectively together they are inconsistent. So what you will going to do, you will going to put a challenge to that as a composite measure. And remember this thing, that whenever you see panel or appellate body, how they examine it, they examine a particular measure in totality, not individual level. Okay, so this is the meaning of composite measures. And next, if you will going to see the complaints, this is also a very frequent part of the complaints. How you are challenging a particular measure, is your challenge is as such as applied. Now what is the meaning of as such over here? Let's say India, hypothetically assuming, has come up with a particular measure which says that from 2027 onwards we will going to charge 500% of import tariff on each and every item which will going to come to India. Okay, and you all are aware that this is something which is inconsistent with India's WTO obligations, and more specifically market access commitment, okay, under Article 2 of GATT 1994. So this is a clear-cut violation. Now the thing is, the law very clearly says that when are we supposed to impose these 500% import duties? They will going to start it from 2027. Now, will you going to wait for the application of this particular inconsistent measure, or you will going to challenge that particular measure before its implementation? Okay, so if you decide to challenge it before its implementation, and you know that this is an inconsistent measure, this is known as challenging a measure as such. You are not waiting for the implementation of it. You have just thought of challenging it as such. Okay, because you know this thing, and this measure is passed in 2006. This is an inconsistent measure. I don't have to wait for the application of it. Okay. Second, which you will going to see in the complaints, is sometimes you challenge a measure as applied. Let's take the same example. Hypothetically assuming India passes a legislation in 2026, Jan 2026, stating that from 2027, Jan 2027 onwards, we are going to impose 500% import duties. Okay. Now what you are doing, you will going to wait till 2027, and in 2027, when India has started imposing these increased 500% tariff duties, okay, so you will going to challenge it as applied. You know this thing. Okay, the measure was an inconsistent measure. Now the application of inconsistent measure is done by India. We are challenging it. So this is pretty common in all the WTO dispute settlement cases. Okay, sometimes the measures are challenged as such, sometimes measures are challenged as applied. And there is a possibility also you can challenge a measure as such and as applied also. So there are various permutations and combinations. Okay, just remember this thing. Either you can challenge a measure as such, or you can challenge a measure as applied, or you can challenge it as such and applied. There are so many cases are there where you will going to find challenge as such or as applied or both. Okay. The next which you will going to see is US Inflation Reduction Act. This is a most classic example of challenge as such and as applied. Okay. US has come up with the Inflation Reduction Act. The purpose of this is to encourage the production manufacturing of EV batteries in US. Now this particular legislation, it provides for some tax incentives. Okay, it has a requirement of local content also, and all these provisions which are there in the Inflation Reduction Act, they are in violation of various GATT 1994 provisions, okay, and the other WTO agreements also. And what China has done in this particular dispute, China has challenged this as such also. They have challenged the inconsistent measure also, and they have challenged the application of this particular measure also. So this is an example of challenging a particular measure as such and as applied. Now, the story doesn't end here. As I have told you this thing, that this is something which is very complex and crucial, but though the understanding, once you have understood it, okay, they are not that challenging. The other way of identifying and challenging a measure is, first you have to identify it, whether a measure is a mandatory measure or a discretionary legislation. Now understand this in such a way that from 2026 onwards, India will going to impose 500% import duty. You have given the instructions to your authorities, custom authorities, from 2026, start charging 500% import duties. Okay, now there is no discretion left over here. From 2027, you will going to impose these increased duties. So this is something which is known as challenging a mandatory legislation. And remember this thing, mandatory legislations, they can be challenged as such also, as applied also. And other than that, you have a discretionary legislation. Now discretionary legislation, there is some sort of discretion is given to the authorities. Okay, law itself is not making a mandatory violation. Okay, it is the way it will going to be applied. Let's say the application part of that lies with the administrative authorities. How the administrative authorities will going to apply, and whether that application will going to amount to the violation or not. On that basis, you can challenge that as a discretionary legislation. But remember this thing, the classification of mandatory versus discretionary legislation comes handy in identifying the complaints as such as applied. If it is a discretionary legislation, okay, when can you challenge it as such or as applied? Okay, when it is actually imposed. A mandatory legislation is there, you know this thing that there is a violation, you can challenge that as such, or you can wait for the implementation then as applied. But in discretionary legislation, you cannot challenge it as such, because on face of it there might not be a violation. When it is applied, then only the violation will going to come up. So you have to understand these distinctions also when you are challenging it as such and as applied, because these are very crucial distinctions. And I will going to encourage you that please go and read a particular report, okay, of panel and appellate body. I am not asking you go through the entire report, but at least try and understand it, that how the challenges are made by the complainants. Okay, and in the factual aspect also, you will going to have a very clear cut idea that how they are challenging it, whether it is a written measure or an unwritten measure, or mandatory or discretionary, and if it's a mandatory or discretionary, how they have applied the distinction to that as such versus as applied. Okay, I hope you have understood this particular aspect. Now remember this thing, in the initial sessions I have given you a classification also, the types of complaint. DSU provides for three types of complaints, and the most popular form of complaint is violation complaint. When there is a violation of any of the WTO provision, you will going to file a complaint that is known as violation complaint. But at the same time, under Article 26, there are other possibilities, other types of complaints are also there. They are known as non-violation complaints and situation complaints. Non-violation complaint means, very simply, if you have not violated any of the WTO provision, but still the other country was expected any sort of market benefits, and those market benefits are denied now, so that particular country, WTO member, will going to file a non-violation complaint. Okay, because I was expecting market access benefits, and because of your any action which might not be in violation of the WTO provision, but I am not getting those benefits, I will going to file a non-violation complaint. And the third is a situation complaint. Now remember, this thing, situation complaint has not been utilized by any of the WTO member, because this is something very difficult to prove. Okay, and we have already discussed, we had already sufficient discussion on these points in the previous classes. Okay, so I'm not going to repeat this particular part again, but the focus should be on violation complaint, and to an extent non-violation complaint, because situation complaint is next to impossible. You will not going to see any complaint which is being raised by any of the complaining member and they argue that this is a situation complaint, because first it has to be a violation complaint, and if not a violation, then non-violation complaint, and then the third is situation, which is like impossible thing to happen. Okay, so with this I'm going to end this particular session. Just to give you a quick recap what we have learned today, we have started with the types of challenge which are brought by WTO members when they file cases. These complainants can be for challenging a measure which is a formal, a written measure, or a unwritten measure. After that, challenging a measure as such, as applied, that also we have discussed sufficiently. And then what amounts to mandatory legislation, what amounts to discretionary legislation, and after that, types of complaints, which are violation complaints, non-violation complaints, and situation complaints. In the next session, we're going to discuss upon who are allowed to bring a dispute to the WTO dispute settlement mechanism. Thank you.